Excellencies, distinguished guest participants, ladies and gentlemen, Om Swastiastu. Welcome to the Faculty of Law, Universitas Udayana, today January 17, 2025 for the opening ceremony of the academic seminar on the importance of comparative law, method and approaches in legal research. This international seminar is organized by the Bachelor of Law Program Study, Faculty of Law, Udayana University. Before we enter into our main agenda today, we would like to invite all audiences to sing the national anthem of Indonesia, Indonesia Raya. Therefore, for the audiences to please stand up. And for the committee to please play the anthem. Thank you for all the audiences to please remain standing up. Obviously, we're going to continue our agenda with prayer for the success of today's event. We would like to invite all audiences to pray according to your respective belief. Prayer is started. Prayer is finished. For all the audiences, you may be seated. Excellencies, distinguished guest participants, ladies and gentlemen. As for our next agenda, now please warmly welcome the Dean of the Faculty of Law, Universitas Udayana, to deliver his speech that will also officially open the academic seminar on the importance of comparative law method and approaches in legal research. To our Dean, Bapak Profesor Dr. Putu Gede Arya Sumertayasa SH Hum, the time and place are yours.
Good morning, distinguished guests, honorable speakers, and participants. It is an honor for me, on behalf of the Faculty of Law, Udayana University, to welcome all of you this international seminar on the importance of comparative law, methods and approach in legal research. First and foremost, I would like to extend our heartfelt gratitude to our keynote speaker, Prof. Tamara Hervey. Selamat pagi. Professor of Law at the City Law School, City University of London, UK. Thank you, Professor, for sharing your invaluable experience and enriching this seminar with you vast knowledge. This seminar holds special significance as a cornerstone for the growing collaboration between the City Law School London and the Faculty of Law Udayana University. I sincerely hope this collaboration continues to grow, fostering mutual understanding and advancing legal education and research in both institutions. The topic of today's seminar is about timely and essential comparative law, with its focus and understanding different legal system, methods, and approach. It's a critical tool in addressing the complex legal challenges of our global world. Ladies and gentlemen, with this, I would like to officially declare the International Seminar on the Importance of Comparative Law, Methods and Approach in Legal Research open. Thank you.
Terima kasih Bapak. Excellencies, distinguished guests, participants, ladies and gentlemen. That was the opening ceremony for today's agenda, and we would kindly invite the Dean, the speakers, the moderator, and the committee chairman to come to the stage to the photo sessions. And we would like to also invite Professor Tamara Harvey to the delivery of a token appreciations. Baiklah, yang pertama kita foto dulu ya Bapak Ibu sekalian. Izin saya pandu. 1, 2, 3. Sekali lagi 1, 2, 3. For the audiences, please standing up. Dua, tiga. 1, 2, 3. Maybe with our original signs, meroket. 1, 2, 3. Ya, baik. Terima kasih. And we are going to continue our sessions for the delivery of token appreciations. Excellencies, distinguished guests, participants, ladies and gentlemen, finally we arrived at our main agenda in today's academic seminar on the importance of comparative methods and approaches in legal research. We would like to inform that the presentations as well as the questions and answer sessions for today is going to facilitate by Bapak I Gusti Ngurah Parikesit Widya Teja, SHM Hum LLM PhD as the moderator. And the speaker for today's event is Professor Tamara Harvey, LLB PhD, Fellow of the Academy of Social Sciences, Principal Fellow of the Higher Education Academy, member of the Faculty of Public Health. Ladies and gentlemen, without further ado, we would like to invite Bapak I Gusti Ngurah Parikesit Widya Teja, SHM Hum LLM PhD, to please come to the stage to facilitate these sessions. Please give applause for Bapak I Gusti Ngurah Parikesit. Ladies and gentlemen, Bapak I Gusti Ngurah Parikesit Widya Teja, SHM Hum LLM PhD, is a lecturer in International Law Department at Faculty of Law Udayana University. He is also the coordinator of Learning Development and Quality Assurance Unit, Faculty of Law, Universitas Udayana. He obtained his bachelor degree from the Faculty of Law, Universitas Brawijaya, while for his master degree from the Magister of Law program, Universitas Brawijaya, and LLM program from the University of Washington. He obtained his doctorate degree from the University of Melbourne. Without further ado, Bapak I Gusti Ngurah Parikesit Widya Teja, the time and place is yours.
Thank you for the time and opportunity. All distinguished and honorable speakers, audience, organizing committee, all the Faculty of Law Udayana University leader. We have the Dean, Vice Dean of Academic Affairs, the Vice Dean of General and Financial Affairs here. It is definitely my honor to serve as moderator in this special occasion. This title is Academic Seminar regarding the importance of comparative law, method and approaches in legal research. This event is special for some reason. The first, this is the first event, the first academic activity organized by Faculty of Law Udayana University in 2025. This is even more special because we have privilege of hosting an international speaker with a topic also important, because when we talk about comparative law, we will learn about the similarity, the difference between each legal system. And for our national legal system, it can be a breakthrough for better legal reform and policy development. And by doing this international seminar, it will initiate all kind of international collaboration between Faculty of Law and other institutions overseas. Without further ado, allow me to invite the honorable speaker. Here comes Professor Tamara Harvey from City Law School, City University of London. Please come and join with me on the stage. And please give applause to her. Okay, before starting her presentation, I'd like to briefly read her curriculum vitae. Professor Tamara Harvey is a Jean Monnet Professor of European Union Law at Personam at the City Law School, City University of London. She studied at Glasgow and Sheffield and has held academic position at Durham, Manchester, Nottingham, and Sheffield Law before joining City Law School in 2021. Professor Tamara integrates research with teaching, particularly by involving students in her project. For over 30 years, she has taught modules informed by her research, such as European Union law, where her work on the EU and UK relationship and the European Union's internal market. Her research often incorporates student collaboration, like as information, Faculty of Law and City Law School, now under collaboration in Gender Equality and Law Project, where 10 Faculty of Law students with 10 students from City Law School create a kind of collaborative class to reach the goal or outcome in co-producing research that will be published in some academic series in City Law School and also in Law Faculty Udayana Journal. So this is not just a plan, but we have done it, and we are plan to complete the collaboration in the next June 2025. Without further delay, I'd like to invite Professor Tamara Harvey to start her presentation, and you may sit or you may stand up to the audience. Time and place are yours.
Good morning, colleagues. Selamat pagi. It is a great pleasure to be here with you today. I would like to thank the Dean very much. Some technical moment. Better like this? Is better like this. Good morning, colleagues. It is a great pleasure to be here with you all. I would like to thank the Dean and the Vice Deans and organizers of this international event. I'm honored that this is your first academic event like this of 2025. I would also like to thank my dear colleague, Sigit, for this invitation and for the collaboration in transnational legal education on gender equality and law. I am learning from you, Sigit, my colleague, and also from the students, and I bring warm wishes from the other participants in the project in London. Let me turn to the topic for today. Comparative law. How should we learn from each other? What should we learn from each other? How should I learn from you? How should you learn from us? Maybe, please, could you advance the slide? So we share common challenges as human beings, as fellow human beings. We enjoy common opportunities, and we face common change all the time. As human beings, we share dignity. We share human rights. We share autonomy, and we share solidarity, a sense of responsibility for each other, for our families, for our communities, for our nations, and for the shared planet that we live on. And law has a unique place in constraining what we do as humans and enabling what we do together as humans. And this is true of law everywhere in the world. Any kind of legal system, any time, any place. Law constrains, law enables. Where we share enough, it is useful, or it may be useful, to understand experiences in other places to improve the law. Next slide, please. Most legal topics involve these common shared problems. Every society has criminals, unfortunately. Every society must arrange economics and commerce. Every society needs law for family relations, when a family is formed, responsibilities to children, when a family relationship breaks down, when a family member dies. Every human being gets sick from time to time, so every legal system needs something about medical law. Every legal system needs to understand how people should be treated at work, so every legal system needs employment law. When people cannot provide for themselves, we need to care for them as a society. That's where welfare law comes in. Because human beings are equal in dignity, every legal system needs equality law. Also, where there is a government, we need administrative law, we need constitutional law. We share all of these facilitations of law and constraining factors of law. And we are also responding to new technologies all the time. So we are thinking, this generation is thinking, how should we respond to artificial intelligence? How should law constrain the use of artificial intelligence? How should law enable the benefits from artificial intelligence? We have a common problem in terms of the platform economy, where work relations are changed. Or financial services. We saw with the global financial crisis that no legal system managed to constrain the financial services industry in a way that would protect people from the financial services crisis. And there are more shared common new technologies, new issues that we share. Next slide, please. In the literature on comparative law, there are two main ways of thinking about comparative law, methodologically speaking. And probably the most common one, the best known one, is a functionalist or instrumentalist approach to comparative law. And I have a few slides here explaining what this approach is about and what it means. In this approach, comparative law is searching for a better solution to a national legal problem. It's searching for a better solution by reforming legislation or by changing the way judges reason or by changing the way lawyers argue or advocate when they make a case or a claim. So let me talk to you about one example here. This is a health law case. It involved the United Kingdom, and it concerned the liability of the United Kingdom for blood that had been infected with hepatitis C. And in this case, the court held that blood is a normal product when we think about liability, when we think about damages for harm caused by the product of blood. Next slide, please. And to reach this conclusion, perhaps a surprising conclusion, that blood is just like any consumer product we buy, like a kettle or a piece of clothing. It's just a consumer product. To reach this conclusion, the court refers to 5 different legal systems in both the common law tradition and the civil law tradition, and it looks at the law and legal practice in 8 European countries and the United States of America. So it uses comparative law to reach its conclusion. And it also considers different language versions of the relevant legal text. This is a text in European Union law, a piece of legislation that has authoritative instances in many different languages. Next slide, please. So in this functionalist or instrumentalist approach, we're searching for a better solution. And that better solution might be considered internally. So we think about how consistent is our internal legal system? How neat is the legal solution? But more often, it's being considered from the point of view of an external standard, usually to improve the efficiency of law. How efficient is the law being? And by efficiency, we often mean the capacity of law to create wealth. Or we might mean economic efficiency in a formal economics way. But it could also be efficiency from another perspective. Let's say from the perspective of human rights or dignity. How might the law be more efficient in that point of view? Not an economic point of view, but a human dignity point of view. Next slide, please. And so in this functionalist approach, this instrumental approach, we use comparative law to understand our own system better, to see our own system in the light of what other legal systems have done, to enhance our domestic legal discussions, the discussions that happen in a court when you bring a case and you make an argument. And if we are humble enough to learn from others and to be inspired and to understand other legal systems, that makes us better lawyers. Outward-looking lawyers who are curious about other legal systems are better lawyers in their own domestic system. Being isolationist does not make for good lawyers or for good legal science. Good law professors should also be curious about what happens in other parts of the world. And partly, that's why I'm here, because I'm curious to understand about your legal system and how we can learn from you and from each other. And also, this approach to comparative law can be used to improve legal education, because as legal educators, we can explain more about the law we're teaching by comparing it to the legal solutions reached in other legal systems. Next slide, please. But this approach to comparative law has important limitations. And as good lawyers and good legal scholars, we should be aware of the limitations of this method. If we are going to compare, we assume that we can generalize. We assume, for example, that planning law is generalizable in every country or the countries that we are comparing. We assume that the needs of planning law are the same in each country that we compare. And this morning, I learned that there is a need of planning law here that is not a need of planning law in London. Your planning law needs to respect your cultural and religious traditions in a way that our planning law does not need to. So that is an example where perhaps we cannot compare law, or we need to be careful when we compare law. Maybe you can be thinking, what is this area of planning law where we have to respect religion and tradition, and in London they don't respect that? Maybe you can think about this after the lecture in the questions and answers. Maybe you can tell me what you think it is. Maybe you can tell your friend what you think it is. So the topic, the area of law that we're comparing, needs to be sufficiently generalizable and recognizable in both the jurisdictions, the two countries that we compare. And we recognize that topic or area of law by thinking about the legal principles that surround it. What are the legal principles that surround criminal law, for example? We must not retrospectively impose a criminal penalty. The criminal act must be a criminal act at the time that the criminal act took place, for example. That is a generalizable legal principle that exists, I believe, in every legal system. By reference to the legal logic, so the legal logic has a rule, and then maybe there's an exception to the rule, and maybe there's an exception to that exception. Perhaps you experienced this when you learned and studied law. So sometimes the rule has so many exceptions in the legal logic that there's almost no rule, because it's all exceptions. Maybe you already experienced that when you learned some law. But as legal scientists, as lawyers, we think about a systemic coherence, a way that the system creates a field of law, like criminal law, or planning law, or equality law, or medical law. And if we don't have comparable coherence, we can't compare. So if a topic belongs in one area of law in one country, but it belongs in another area of law in another country, comparison could become meaningless. This is a limitation of comparative law. Next slide, please. So as I was saying, law is sensitive to its local environment. The best legal scholarship must be aware of the contexts where law is made, is interpreted, is applied. And that means cultural, political, historical, religious, societal considerations are important. We cannot naively assume that legal solutions that work in one country will work automatically in another. Or as John Harrington put it in 2000, legal reasoning establishes truths that are only provisional or contingent. Next slide, please. I want to say this, though. We can learn not just from what is the same, but also from what is different. We can learn from our differences as much as from our shared contexts or values. This is a different approach to comparative law. Next slide, please. This is usually known as an explanatory or a critical approach to comparative law. So we have the instrumental and we have the explanatory. And here, the focus is to use comparative law to explain or understand the history of a law in its contemporary context. How did the law come to be how it is now? And if it's a critical element, with a capital C, it's also trying to use comparative law to uncover the power relations that determine the way that the law is. So to uncover the power that is hidden within the law, because law presents always as equal, treating everybody equally. All are equal before the law. Law always presents like this, but law hides power dynamics. And when we study gender equality law, for example, we see how neutral law can sometimes hide a power dynamic, a disparity between the way men are treated and the way women are treated. Not on its face, not explicitly, but hidden within the law. And this is a way to use comparative law to understand those power dynamics. Or, as Samuel put it in 2014, the law emerges from the cultural domain, like a building, a piece of architecture, or a song, a piece of culture. Next slide, please. Or, as Munshi put it in 2017, bear with me and read with me, it's a long quotation. The fabric of any legal text, so what the law text is made of, consists of historical configurations enmeshed with traces of political rationalities, entwined with traces of social logics, interwoven with traces of philosophical postulates, plaited with traces of linguistic orders, darned with traces of economic prescriptions, interlaced with traces of epistemic assumptions. And I love this quotation from Munshi because she uses a women's activity, weaving, sewing, mending, creating fabric, to describe a male activity, creating law. So that the metaphor is very beautiful. Next slide, please. In this approach, comparative lawyers make explicit what is specific about the place and the time that they study. And they talk about the cultural, the economic, the social, the political arrangements, and how those are embedded in the law. And they explain how those are hidden in what seems to be a neutral legal text if you approach the law as if law was only principles and not embedded in the contexts in which it is created. Next slide, please. And if we do this, we can be good comparative lawyers because we don't make assumptions, embarrassing assumptions, about what we could learn from each other and what we could transplant from one legal system to another. So, for example, in medical law, New Zealand and Sweden have a no-fault liability system. So if there's a medical law liability, you do not have to show fault on the part of the doctor or the hospital. You as the patient, will receive compensation. But that is embedded in many specific institutional, economic, and cultural contexts in Sweden and New Zealand. We could not just take that rule and transplant it to the UK because it would not work. And this mode of comparative law, this approach to comparative law, helps us to see this and not to make naive, stupid assumptions. Oh, we should have no fault liability in England. It's a good idea. We can't just naively assume that they could be transplanted. Next slide, please. So now I want to tell you about a real project. So I told you a lot of theory and reviewed the literature in comparative law, but now I want to tell you about a real project and how we really balanced the best of these two different approaches to comparative law method. And we did this in a practical way. So you know, when you're doing your studies, you have to perhaps write an exam or an essay or a research paper. Perhaps you're doing a PhD. You have to solve your research puzzles in a practical way. So we said, let's not exaggerate local context. Let's think about the shared understandings that law is based on, about the nature and value of human life, about autonomy, about community, about the value of economic development, about the need for sustainability in a world sharing climate crisis. Let's think about what we have in common, and let's think about where these common ideas come from. They often come from philosophical or religious traditions or precepts that actually go beyond one single country or one single culture. Next slide, please. And we say, well, let's be explicit. Let's make those assumptions clear. Bring them to the surface. So law on genetic technologies, for example. All countries have to think about how to regulate new genetic technologies. In many, maybe all jurisdictions, that law is based on human dignity and the concepts of autonomy and informed consent. And then think about, are those assumptions ones that go across national boundaries, or are they different in different national contexts? Think explicitly about that. Do not assume that they are the same everywhere. And learn about our own law by putting it alongside other systems, how judges reason or how legislation is written. Next slide, please. And then use that knowledge to argue for legal change in our own system, paying attention to our time now and our place, thinking about comparative law as a project of legal reform. It can help us, comparative law can help us to see that our law is contingent. It's not fixed. We can change it. We can argue for better law. And we can argue for better law from a stronger position if we are comparative lawyers. And comparative law can also be used in practice to stretch our imaginations upwards, to understand and to say what could be better, to articulate the possibilities for better law. Next slide, please. And in all this, we must respect other disciplines, sociology, cultural studies, economics. But we must also remember that as legal scientists, legal scholars, lawyers, we bring a lot to understanding the world. So don't lose sight of the contributions that law makes, the way that we understand law, the way that we interpret law, legal hermeneutics, how law is interpreted. Do pay attention to those other contexts, but do not lose sight of law, legal scholarship, the methods of law. Because just as culture and economics and politics shapes the law shapes the non-legal world too. So it's important for us as legal scientists, as scholars, as lawyers, to take our place in the world, to make change for the better. And to understand how law, legal text, the meaning of law, can shape the world and have implications for the people in the world. Next slide, please. So here briefly is an example of a project that took this practical approach. And this is a project published by Oxford University Press. Next slide, please. So here we were comparing the United States and Europe, and myself and David Orendleicher, my collaborator, drew on our networks in each place. We were humble, if you like. We were aware that we could not offer a global comparative law project because we only knew about the USA and Europe. Only an insider can offer this kind of insight because of the way that we are trained, because of the way that we see the world, the way we are educated. Next slide, please. Yes. Thank you. Next slide, please. Thank you. Brill. So in this project, we acknowledged how different Europe is from the USA. Europe has states. The USA is a federal system with constituent states. Europe has many independent countries. And we did acknowledge important voices and jurisdictions outside of Europe and the USA. And we asked our comparators, where possible, could they please draw on those voices and jurisdictions. So we were looking at health law, at medical law, where, for example, the regulation of clinical trials is very important in the global south because many clinical trials take place in the global south, not in Europe or in the USA. We were aware that access to essential medicines is very different in, for example, African nations than it is in the USA or Europe. And we also asked our collaborators to think about international law, not just national law, because, for example, tobacco regulation is covered by UN law, international law. Next slide, please. And then we selected our collaborators very carefully. Our authors knew about the law in the USA, both at the federal level and in at least one state. And our authors in Europe knew about national law in one country, like France or Germany, but they also knew about the Council of Europe or the European Union. And we asked our authors to pay attention to the norm of regulating the area of health law that they talked about, and the states that were different, the outliers. So, for example, Switzerland and Oregon have very different rules about decision-making at the end of people's lives. They allow for much more autonomy in terms of end-of-life decision-making than the norm in the USA or Europe. Or, for example, Iran has a very different approach, legal approach to organ donation than any country in Europe or the USA. Or, for example, Poland or Texas have a very restrictive approach to the right not to procreate compared to the norm in the USA or in Europe. The norm in the USA is changing very rapidly at present because of the new post-Roe v. Wade legislation, judgment, which you may be aware of. Next slide, please. So the aim was to produce an authoritative set of essays covering health law comparatively between the USA and Europe. And we wanted our authors to articulate the full range of discussion, opinions, debates, controversies in this field. And we wanted them to define legal understanding, but we also wanted them to advance legal understanding, to give their views, to say how they thought the particular topic of medical law should go forward. Each chapter is therefore a piece of critical analytical work, surveying the essential questions. What should we do about end-of-life decision-making? How much choice should parents have over medical decisions to do with their children? What about if their children are age 15, 16, 17? What should we do about medicines supply? How should we ensure equality in access to medicines? All of these important questions in health law were covered in one or more chapters in the book. And we asked our authors to think about the contemporary perspective now. And the aim was to learn from the different ways in which health law takes place in Europe and the USA. So this was the evaluative or critical method that I outlined before. Next slide, please. And we asked our authors to think about the space. Was the law for the state, for a nation state, for a federation? Was it for the European Union? Was it for a regional human rights organization like the Council of Europe? We asked them to consider the time. What were the economic, the social, the cultural, the political backgrounds that led to the law, the way the law is now? And we asked them to consider that legal rules are never completely separate from the contexts in which we find those legal rules. But we asked our authors always to keep law in the center of the analysis. It's legal scholarship, so law is always the central focus. Next slide, please. And we asked our authors to research together collaboratively and to write together collaboratively. And this is what we are doing also on the Gender Equality and Law project. So the authors were in a pair of two or a group of 3 or 4, 1 or 2 from the USA, 1 or 2 from Europe. And we asked them not to write separately and then bring it together, but to write together. To first write together a review of the topic at issue. Was that end-of-life decision-making? Was that regulation of doctors? And as an inspiration for their review, we thought, could you think of common principles? Human dignity, for example, or consent. Or could you think of a real-life example, a real case, a famous case, or maybe even a story, a fictitious example from a book or a film to help you to write your initial review on the topic. Next slide, please. And this invitation to write together, to research together, meant that our authors had conversations, and those conversations started before they started their individual work. And the conversations meant that the context, the spatial, the temporal, the time, the place, that became more apparent. And our authors learned more about each other's jurisdictions because we asked them to co-write. So that, for example, the pair of authors who were writing about public health protection, the European author was astonished to learn that in the USA, gun control law is part of public health law. In Europe, gun control law is not part of public health law, but in the USA, gun control law is covered. So there was learning, there were conversations. Next slide, please. You can imagine, we asked senior professors in different countries, please can you write together? You can imagine they had very different styles. They preferred to write, they preferred to work in very different ways. Because they'd been educated differently, because they normally write differently, and so on. But as the conversations went on, as the learning went on, the differences became less important. And we as editors, David and I, also had conversations, but we inputted into those conversations. We had Zoom calls where we talked together with the people who were writing for our book. And this has been called by Samuel an insider-outsider approach. So you are an insider in your own system and you recognize you are an outsider in the other system, but you try to understand as best you can as an outsider, and at the same time you share as an insider. And that helped to make it so that people could communicate and so that the comparison was meaningful. And this approach, this insider-outsider approach, was based on profound respect, profound and mutual respect of the other. Next slide, please. And in our project especially, the profound respect was very important, because you can have legal situations where the most powerful gets to decide what matters. This kind of legal hegemony, the powerful decide. So where the first person to write about the field, or the person with the loudest voice, with the most resource, they get to determine what matters, what counts, and therefore how we describe, how we analyze the law. And we wanted to be very careful to make sure that the US voices did not dominate the European voices, especially in the smaller European countries. And we used this concept that Whitman articulated in 2017 of empathy, a German word, einfühlen. An understanding of a foreign time or place requires a practice of Einfühlung, of empathetic understanding. And that has to happen at the level of the individual scholar. The individual professor must be respectful and empathetic. Or another way that this has been explained in the comparative law scholarship by Miller is a duty of hospitality. So we are working together. I owe you hospitality. You owe me hospitality. It goes both ways. It never only goes one way. Next slide, please. And we tried to engender a certain humility. You can imagine some professors maybe don't appear very humble. Of course, all law professors always appear very humble. That was a joke, but not a very good joke. We needed, as I said, to counter the power of the USA, and we had pairings of very senior professors and more junior professors. So we needed to make sure that the junior professor was not too respectful and that the senior professor was respectful enough. So as best as we could, we tried to make sure that there was no domination of one side of the other. And in this, we take the view that mutual respect and self-reflective humility are the core values of a practical common comparative law method. Don't put yourself in the center. Don't generalize or globalize what you see in your nation. Next slide, please. So the way we worked with the common introductions meant that our authors thought critically about how their legal knowledge was usually structured. So the US author thought, oh, why do we include gun control in our public health law? Well, because we have a very big public health problem in the USA because of gun control, or rather because of gun freedom. In other countries, they have less gun freedom, so it's less of a public health problem. And we asked our authors to move beyond the questions obvious to them to think about more shared questions, and move beyond their own normal, invisible intellectual habits about thinking about the law that they study. And that meant there was a reflexive aim behind our whole project. So this was a practical example of how we used the comparative law method. Next slide, please. So I move now to some very brief conclusions before welcoming any questions or discussion or observations, and of course any responses from my esteemed colleague. Next slide, please. I asked at the beginning, comparative law, how and what should we learn from each other? How should we learn from each other? We should learn with mutual respect and dignity. Not too much respect, not too little respect. We should be humble. No one person can understand any legal topic across the whole world in any way. We have to collaborate to understand the way law works in different countries and different parts of the world. What should we learn from each other? We should learn that law is culturally, historically, politically, economically, socially contingent, but that law is also important, and we can learn a lot from each other, including understanding our own systems better, as well as understanding another system with useful ideas that might be brought back home. Next slide, please. These are the sources that I used for my talk. Next slide, please. Thank you very much.
Thank you very much, Professor Tamara Harvey, for the great materials. I myself learned a lot from the material you have presented. And again, talking about comparative law, it is very important and significant, even for myself. I earned my PhD because of the thesis talking about comparative planning law between Indonesia and Australia. And almost all my research project talking about comparative, like comparative planning law or comparative administrative law, and etc. And here in Faculty of Law, Diana University, especially in graduate program, almost all lecturers encourage students to do comparative law, especially when we talk about doctrinal research. Then we find that some existing laws or regulation are unclear, conflicting, or even absent. Then by doing comparative law, by putting some experience from other jurisdiction, it will give you any idea, any perspective to solve the problem in your final project and thesis. That's why today's event is pretty important to increase our understanding in doing comparative law. Thank you again for Professor Tamara Harvey. And I will open the discussion. The next step is this discussion, where all audience are invited to express either question, information, or even any concern regarding the importance of comparative law. So I will invite 3 participants to raise the question. Who would like to be the first? Just raise your hand and don't forget to mention your name. Okay, who would like to be the first from the audience? Yeah, the first one, I think, Leah? Yeah. Leah is one of the students.
Thank you so much, Pak Sigit, for the opportunity. And hello, Tammy. My name is Leia. Maybe you have known me before. I'm apparently one of the participants on the Transnational Legal Education too. So first and foremost, thank you so much for coming here, coming to Udayana University, coming to Indonesia, giving us a very meaningful explanation on legal comparative research itself. And I have two questions. The first one is, would you say that there are instances where comparative approach cannot be applied in a legal research? Let's say if there are too big of a differences in the socio-cultural context, and if we deem that the solution would be redundant in the sense that maybe if we were to compare Indonesia and USA, and then it can be applied there, but the result would end in you do you and we will do our legal framework itself. Do you think that comparative legal research is still needed, or it should not be done? And the second question would be, does comparative legal approach highly needs authors coming from 2 or more different jurisdictions? Let's say if we were to make our thesis on comparative legal research on Indonesia and New Zealand, but there are limited resources where we cannot have those kind of discussions with authors coming from that jurisdiction. Would that reduce our credibility? Or if I can reframe my question, would be, how can we keep our credibility in absence of authors coming from different jurisdictions? Those are my questions. Thank you.
Yeah, thank you. And I think Professor Pramana would like to directly respond it. Yeah.
Thank you so much for your questions. And it's a pleasure to meet you in person. We already met on Zoom. So those two questions are the questions of comparative law scholarship. So you only asked me to summarize all of comparative law scholarship in my response. Thank you. But I'll tell you my view. So I think that there are circumstances where the functional or instrumentalist approach to comparative law is not appropriate. And I think there are many of those. Because to simply assume that we can take law from one place, let's be clear, that's usually the global north, and put it in another place, usually the global south, that is not correct. So that approach to comparative law, I think there are many circumstances where it is not appropriate. But the other approach to comparative law, the other approach to comparative law, the critical, the one where you are learning as much about your own system as the other system, and where you're not assuming that you can transplant law, but you're still arguing for legal change and for law to be better, I think there are many more circumstances where that is appropriate. And that's why I introduced you to both modes of comparative law. In terms of your second question, this is much more like, how can I do a practical comparative law project with the resources I have? And that's exactly the kind of question that David and I faced when we did our comparative law project that I described. So just like a PhD student here in Udayana has a limit of resources, so David and I had a limit of resources when we did our comparative law project. And for me, the solution there is always to be honest about the limitations of your resource. So we were not experts, and we did not have in our team any experts from the Global South. So we said to Oxford University Press, we cannot write a book that is a proper global comparative law book because we don't have the resource for that. We can compare the USA and Europe. And Oxford University Press said, okay, we'll start with that. I think they would like to do a true global comparison in the end. And then to be clear, within these limitations, this is what I can offer. So I'm a PhD student, I'm trained in the law in Indonesia, but actually I'd like to study law somewhere else as well as part of my PhD. And I will study it in these ways. I will read the legal texts. Maybe I'm fortunate and I have the resource I can go and visit. Maybe not. But if you are clear in your PhD, in your book, in your journal article, these are my limitations, but then also claim this is what I can contribute. Because legal scholars should not be shy to say, we have this to contribute to the world. We have this understanding of the law, of how law can make things better. So that would be my answer to your second practical question. Thank you so much.
Thank you for your answer, Professor Tawara Henry. I think if Leah still has a question, right after this event, we can we can meet, because after this seminar, we will have a brief meeting with the student who involved in the project. Okay, for the next participant, would like to raise the question, because we still have time until around 11:30. So, okay, that's right in the corner.
Check. Okay, good morning. Thank you for having me, Pak Sigit and Prof. Temi. My name is Putra. I'm from the Bachelor's of Law program in this university. The questions that I would like is about barrier or the separations between the, as you said earlier, about reasons that we do comparative law is because of the shared values of human rights or human dignity, for example. But there is also a kind of different context of those values being viewed in the global north and global south, for example. In here, the examples that I can give is about the difference of many countries in terms of the death penalty, about the castrations as the method for criminal law punishment. I would like to ask about how are those shared values of human dignity and human rights should be viewed, and what should be reigning supreme? Is that the universal values of it, or is there also different cultural backgrounds that we should be considering? And also the second questions that I would like to ask is that especially here in Faculty of Law, we are being limited. I don't know about everyone's experience, but for me personally, in the specialty of the constitutional law, we are being limited to only compare law in which they are the same legal systems. In this context, the common law and the civil law. So civil law only compare to another civil law countries, and common law also compares to another common law countries. I would like to ask, is this barrier relevant, or is it even exist in the first place? That's two my questions. Thank you.
Thank you. Two more extremely difficult questions for me, which I appreciate. Your guys are really good, Sigit. Okay, so I will deal with the second question first. Common law and civil law traditions are an established way of categorizing legal systems globally. So they are an established taxonomy. So I think every legal scholar and every lawyer should learn about that established way of organizing the world. But I also personally believe that legal scholars should be encouraged to challenge the way that legal scholarship and lawyers categorize law and the world. So I think every new generation of law students and every new generation of law faculty and every new generation of lawyers should question, should push the way that the world they inherited is understood. So that's my answer to your second question. On the first question, it depends on what you're doing with your argument. So I, as an English lawyer, will happily use comparative law and shared human rights contexts to argue to improve English law in the way that I understand those shared values. But I would not presume to argue that for another jurisdiction. That's my personal way of doing comparative law. So I might do a collaborative project where I am working with somebody else who does want to argue about their own system, but I would not impose my interpretation of human dignity on somebody else. I would insist that human dignity is a fundamental, profound basis for law and for all law, but I would not presume to impose my interpretation of human dignity onto somebody else. Now, your question presses me further because it asks, well, what should a human rights lawyer do? Because a human rights lawyer is an international lawyer. They don't come from one jurisdiction. And I guess my answer would be the same. An international lawyer would take the international law understanding of human dignity and impose that international law understanding of human dignity in a comparative law project on the topic that they were studying. Thank you for your questions.
Please give applause to Putra and also Professor Tamara Hervey. The question is getting harder, but we are still enthusiastic to receive more questions. Then I'd like to invite all of participants. If you still have questions, this is your chance. If you are doing your final project or thesis, for example, and you get stuck with the idea to employ comparative law, this is your chance to raise any important question to Professor Tamara Hervey. Okay, would like to raise a question again? Yeah.
Okay, thank you for the time, Professor Tamara. My name is Komangari Wibadi Putra, and this question is, recently there have been news reports about Los Angeles experiencing fire issues. Can the application of the comparative law be related to resolving this issue? Thank you.
Okay, thank you. Sorry, thank you for your question. I'm not an expert in this type area or type of law, so maybe you could elaborate a little bit. What kind of contribution could comparative law make to this kind of event? Would you be willing to elaborate your question a little more?
Okay. recently there have been news reports about Los Angeles experiencing fire issues. And can the application of the comparative law be related to resolving that issue?
I mean, comparative law could be used to learn from other places where they experience similar things to Los Angeles and where the law is set up differently to have a better outcome. Is that the kind of thing you have in mind? Is that what he's getting at? Yeah, yeah, yeah.
Uh, so you want to, yeah, how if you just try in bahasa, then I will try to translate it. That's fine.
Oke, bahasa
Yeah.
Indonesia.
Yeah.
Oke. Untuk pertanyaan kan untuk akhir-akhir ini kita akan melihat informasi bahwa tentang berita keberadaan di Los Angeles itu ada isu tentang kebakaran itu, Kak. Apakah dari penerapan dari hukum komparatif ini dapat berkaitan dengan penyelesaian di isu yang ada di Los Angeles itu, Pak? Itu maksud saya.
Thank you. I'm so sorry I don't speak Bahasa. I try to learn, but it's too slow. So can comparative law help with something like the Los Angeles wildfires, is the question. And I would say, yes, comparative law can help with this. So we could think about experience in countries where there is much more control of the environment, of the forest environment, control about who can go there and how they can behave, so to try to prevent fires from starting. We could also learn from the insurance law, about who is insured and how the insurance works after such an event. We could learn from law about mandating people to leave an area because of danger. Many countries experience this, not just for fire, but also for other weather events, calamitous events, this kind of thing. There are many ways that comparative law could contribute to improving this kind of human experience. Thank you. Including planning law. We don't forget planning law. Yes, thank you for your very specific and focused question. Thank you.
Thank you, Komang. I would like also invite another participant to raise some questions. Maybe 2 more questions, then we can complete the seminar. Yes, who would like to be the next? Yeah.
Good morning, Professor Tamara and Mr. Pariksit. Thank you. First of all, thank you for the opportunity and chance that you give to me. I just want to ask a short question about the topic in the Oxford Handbook of Comparative Health Law about the method, you say that Switzerland and origin on the end of life decision making. Can you explain to us what is that means? That's all my question. Thank you.
Yeah, yeah.
Is it possible for your guys to go back to this slide?
It's slide number.
It may not be. It might not be possible. Don't worry if it's not.
Oh,
Yeah, it's okay. Okay, so you're asking about the
About the end of life
the
decision
end
making.
of life decision making.
Yes.
Yes,
Thank you.
absolutely. So I'm not an expert on end of life decision making, and I would have to refer you to the chapters in that book. But what I do know is that most European states and most states in the USA have rules about end-of-life decision-making that do not allow somebody to control or to take their own life. So the norm is the person stays alive and medical science helps them to stay alive for as long as possible. But in a country like Switzerland, they have something they call a dignified death, where the person has more control over how their life is ended and may even formally take their own life in a medically controlled way. That's very unusual in a European context. So that's what I can tell you about that. Thank you for your question.
Okay, thank you so much.
okay, one more question before closing the seminar. Professor Tamara Harvey would like to give like a stadium generally for this for her visit during in Bali, and because we need to shoot to the administrative procedure, then yeah, it will turn into a seminar event, and it's attract more audience. Okay, we would like to have the final questions. Okay, we have.
Thank you so much, Bapak. Hi, Temi. My name is Regina. I would like to ask you a question about the comparative law. Can we only do comparative law just between two countries, or do you recommend comparative law just between two countries, or is it fine to compare several or bunch of countries at once? Thank you so much.
Thank you, that's a great question. So the project that I described compared many countries, many European countries and the USA. So I do think it's okay to compare lots of countries, but I would recommend that a comparative project thinks carefully about its resource. So if you are a PhD project, your resource is you and your time. And so I would recommend that you don't try to compare too many different countries in a PhD. For a PhD, 2 countries is really great, or 3, maybe more if you can somehow resource this. But it really, for a PhD, 2 is fine, or 3 or 4 or maybe more, but keep it small for a PhD. But for a big project or for like a whole career, a professor's whole career, maybe many countries. I think there's no real limit. It depends on the topic, but it also depends on the practical, the resource. Thank you for your question.
Thank you. Give applause for Professor Tamara Harvey, and then we are now entering our last session of this seminar, and what I can say about the importance of comparative law is that, yeah, sometimes we have to see, we have to compare to know our strength or weakness point. So in terms of law, by comparing, we learn about similarity and difference, and it can be a point to analyze or to provide legal analysis for better policy or legal reform. Again, thank you so much for coming to this seminar, and it's my pleasure to serve as moderator to this event, and I will return the event to the Master of Ceremony. Thank you.
Thank you, Bapak. Okay, Excellencies, distinguished guest participants, ladies and gentlemen, please big applause to our moderator and for our speaker for today insightful sessions. For Pak Sigit and Prof. Tamara, please stand on the stage, in front of the stage. Because our next agenda is the delivery of certificate that will shown on the screen. For the committee, please show the certificates. Okay. This is the certificate for Professor Tamara Harvey, LLB, PhD. As our speaker for today's in academic seminar, the importance of comparative law methods and approaches in legal research. And next, this is the certificate for Bapak Igusti Ngurah Parikesit Widyateja SHM Hum LLM PhD as the moderator in our insightful sessions. And for the certificates will be sent at your email shortly. Okay, for our last agenda is the signing ceremony. Pardon me. Baiklah, kepada para partisipan, adik-adik sekalian, untuk yang mengikuti proyek dengan Prof. Tamara dengan City Law School, berkenan untuk tetap diam di dalam aula, sedangkan untuk yang tidak mengikuti sesi dengan City Law School itu boleh untuk meninggalkan ruangan aula ini. Terima kasih untuk partisipasinya dan terima kasih atas pertanyaan yang sangat kooperatif tadi. Izin kami akan melanjutkan kegiatan hanya dengan para tamu undangan dan juga para peserta yang mengikuti kegiatan dengan City Law School. Berikut adalah barcode yang bisa adik-adik scan ya. Nanti ini akan kalian download sendiri untuk keperluan sertifikat di SKP kalian. kalau semuanya sudah mendapatkan sertifikat dan semua dokumennya sudah berhasil di-download, tanpa mengurangi rasa hormat adik-adik sekalian, terima kasih banyak atas kehadirannya. Kita izin untuk melanjutkan kegiatan. Ya. Adik-adik sekalian, nanti diinformasikan, kalian bisa tunggu di depan atau tunggu di sini dulu karena nanti ada konsumsi yang akan dibagikan, tapi masih dalam perjalanan. Mohon ditunggu ya. Kepada para peserta, adik-adik sekalian yang mengikuti proyek mungkin bisa maju ke depan. Adik-adik yang ikut proyek dengan City Law School mungkin bisa ke depan untuk melakukan photo session bersama dengan Prof. Tamara. Adik-adik untuk mempersingkat waktu, mari kita segera maju ke depan untuk melakukan sesi foto.